Today, we're going to finish this state's response to Alex's motion for a new trial. I had already recorded this before the big announcement today, but I thought I'd share it anyway just to finish the series. And because I had most of the work done. I've also got the motion to transfer venue and another big one for you, and of course when it rains it pours. There's a hearing tomorrow morning in Beaufort County to decide some of these motions. Probably this transfer venue motion as well. We are 11 days from the Satterfield financial trial, a trial where Dick and Jim have literally no defense, so they do not want it to happen. Alex has pleaded guilty in federal court for these crimes and sat in the witness chair in Colleton County and confessed them all during the murder trial. He wants the federal trial tucked away before these state ones, so they're trying to stop them because what are they going to say? He didn't do it? They'll look more foolish than they already do, so of course are going to try every dirty trick they can. But we'll cover that hearing after it happens. For now, we'll finish this one up with more on the jury poll, including the sneaky little surprise about one of the jurors and her affidavit. Let's get started. This is Legal Updates with Cassidy. State's response to Alex Murdaugh's motion for a new trial. Part 3. Only Alex Murdaugh could think of such a confounded gambit. Welcome. And I'm sorry my throat is still a bit scratchy as I record this. But I am definitely on the mend, so hopefully the next videos will be okay. So we are picking up at part 3 of this motion, in our part 3 of the series. Part 3 is all about the state's motion to strike. And I've been waiting for this since I first saw these hearsay affidavits when they filed this nonsense back in September. It was sketchy then, and it's even sketchier now that in all this time, they've not been able to trade them out with actual affidavits from the actual jurors themselves. And it's made even weirder by this jury poll, and we'll get to why very soon. So first they cite from South Carolina Rules of Evidence, Rule 801C. Hearsay is a statement other than one made by the declarant while testifying at the trial or hearing we could include in an affidavit, offered in evidence to prove the matter asserted, which is exactly what these two useless affidavits by Holly Miller are. And then it points out that hearsay is inadmissible by Rule 802, which basically says hearsay is not admissible, except as provided by certain rules. Now, I think we all, even with very little legal knowledge, just from watching TV, we understand what hearsay is. It's simply inadmissible without one of the eligible exceptions. South Carolina has 24 exceptions, and they are clearly outlined in these rules of evidence, but none of which are present in this case. And so the state moves to strike these and outlines all the places in defense's motion. I say, good riddance. Now moving on to the content of these affidavits. The rules about this couldn't be more clear. Rule 606 is all about a juror as a witness. And if we just scan especially B, upon inquiry into the validity of a verdict or indictment, which is what's at question here, a juror may not testify as to any matter or statement occurring during the course of jury's deliberations, or to the effect of anything upon that or any other juror's mind or emotions as influencing the juror. The only thing they can talk about is any extraneous, prejudicial information that was improperly brought to the jury's attention. Look at the blue highlighted part. Nor may a juror's affidavit or evidence of any statement by the juror concerning a matter about which the juror would be precluded from testifying be received for these purposes. And if we look at the note in purple, subsection B is consistent with the general rule that a juror may not present testimony as to the deliberations in the jury room as to any mistake, irregularity, or misconduct on the part of the jurors, or which would impeach the verdict or contradict the record. These rules couldn't be more clear. Dick loves to say, "I've been doing this for almost 50 years. As such, he must be so familiar with these rules that he can recite them in his sleep. So how is it that he breaks these basic rules of evidence? It feels to me like malicious intent, because when you know it's against the rules and you do it anyway, there's no other way to describe it. He knew these affidavits were inadmissible, that 2 were hearsay, and that their content goes against the rules, so why file them? For the same reason, he held a big press conference to file this motion in the first place. Beyond the ridiculous cry for attention, it was to make sure people read it and he got this message out there. Once people hear it and the squawkers spread it, it just sort of rolls off the tongue. The jury was tainted. Oh, the jury was tainted. Oh, that verdict wasn't fair. If he can get this repeated enough, whether it's true or not, whether it's admissible or not, whether it follows the rules or not, he can get that false message out there and get people believing it. It really doesn't matter for him what the truth is, as long as he accomplishes that. This type of irresponsible reporting is unfortunately very harmful, and once it gets out of hand, it's impossible to rein it back in. Did you guys see that documentary about the college football player from Notre Dame? It's called Untold, The Girlfriend Who Didn't Exist, and I think it came out last year. It's the story of Manti Te'o. He had such a brilliant, promising career ahead of him. He was amazing, but in his time at Notre Dame, he was catfished by an online person pretending to be this beautiful girl with an illness. He fell for it, and he fell for it hard. When the catfisher pretended to have passed, he dedicated a game in her memory. The crowds ate it up. Everyone felt bad for him. They were praying for her. It was a big deal. He was a really big deal. It was expecting that nearly every team on the NFL was going to try to draft him on draft day. But not long after, it was discovered to be a man that had catfished him. Some very irresponsible reporters put out their version of the story, and though no one was more crushed than Te'o himself, they wrote that he was in on it and insinuated that he was homosexual. The allegations that he had fooled his fans and the world spread like wildfire, and in spite of him being the forecasted most desired pick for the NFL, he was overlooked and it ruined his career. Even though he did continue to play, he was so emotionally damaged by the way he was demonized in media, he lost all confidence, and what was supposed to be the biggest career in football became a sad, lost man that was memed, harassed, and blamed for what was a huge personal heartbreak for him. It's really a wonder that he made it past the urges to give up and even take his own life. It took nearly 10 years for his true story to be told and the catfisher to tell the truth, but by then, the time had passed for what should have been a brilliant football career. Once the documentary spread his truth, people felt really bad for him. He visited Notre Dame afterwards and was greeted by a standing ovation, yet that pain and doubt can never be taken back. His career can never be made up. This is how damaging a few misplaced words can be, and this is why this tactic is used. There's no way Dick and Jim were not aware that the affidavits they put in their motion were against the rules, but now everyone has heard the, not whispers, but shouts that question the integrity of the court, the clerk of court, the jury, and even the judge. It casts a shadow of doubt over the whole proceeding, and it's just that bit of excitement that makes things irresistible to spread and for some to believe. It's a cheat played by defense so that even when it's inevitably struck from the motion and truth prevails and correct decisions are made, people will still be whispering about it and having doubts. And here the state moves to strike this improper juror testimony that's already out there. The state next asks to have that dreaded Facebook post claim, and you know how I feel about that Facebook post claim, struck as immaterial, impertinent, and scandalous. Never have I wanted something struck more than I want this struck. It's the dumbest claim, and I can't believe anyone fell for this. And I love the way the state outlined the lunacy of the whole thing, calling it what it is, an outlandish theory. The theory that Becky Hill made up a Facebook post in order to get juror 785 egg juror removed from the jury, force an outcome, and profit from fame and fortune. Now, I do see her book as an opportunistic move that was very ill-timed. I'm not going to lie about that. I wish she had waited till she was no longer clerk of court and Alex's appeals were all done. In a perfect world, that's what she would have done. Do I think she started making things up on Facebook? No. I mean, just listen to the lunacy. As it says, the machinations do not even begin to make sense. Under Murdaugh's theory, the court received an email, then in immediate response, on the fly, reported a fictitious post to implicate that juror, conspired with another staffer to quickly and by sheer coincidence be lucky enough to find an apologetic post by somebody with the same name as the juror's spouse, then reported it to the court to get an uncertain juror removed so as to ensure some outcome that would support a book deal she didn't even at the time have. And here's where we get the title of today's episode. Only Alex Murdaugh could conceive of such a confounded gambit. It really is just too ridiculous. I mean, where did they even get the idea to spin this narrative? And if you haven't watched part 2 goes into detail of the timing of how this all actually came about. And it's not the way Alex Murdaugh's team has portrayed it. And this quote goes on, only Alex Murdaugh could conceive of such a confounded gambit as even remotely plausible, and he's projecting his own calculating, manipulative psyche onto a dedicated public servant in an effort to save himself. This is such a good line from this document, because it really is along the lines of a deranged mind to come up with such an outlandish tale of events. The kind of man who would spin the tale of Cousin Eddie on the roadside, shooting him in the head, as some stranger who he slashed his own tire. It didn't go flat because, as we learned during the trial, that particular car is designed not for the tire to go flat. So his first lie about having to pull off the side of the road because of a flat tire, ludicrous. Secondly, he gives a whole description, has a sketch made of the person who supposedly did this, and then gets caught in the whole thing and runs off to rehab. Delusional mind who doesn't think before he spins a foolish story. The kind of man who lived in the delusion for over a decade that he was going to get away with stealing millions of dollars with no consequences to himself or those who helped him. That kind of mind thinks up this lunacy. And then the state says as much by saying that this is all here as an attempt to support his writ of prohibition. He had to paint everyone in that courtroom as evil and malicious, so that he could file this writ and try to get the verdict dropped. Then the state reminds us that this juror's removal had nothing to do with the Facebook post, and we went over that in part 2. And so there's nothing relevant about it, and then they move to strike all references to it. Please strike all references to this nonsense. Point 4, even assuming ad arguendo, which means, for argument's sake, that these averred points were true, still, there's no prima facie showing that he is entitled to an evidentiary hearing or relief. Now remember, prima facie means literally at first sight or at first glance, which implies at face value. And prima facie evidence is a pre-trial evidence that's reviewed by a judge and determined to be sufficient or to have enough merit to warrant a trial or a hearing. So the state is saying that for argument's sake, even if we pretend these claims are true, there's still not enough to prove there's any merit for a new trial. Perhaps not even enough merit for a hearing. And then we have this little footnote that reminds the court that Alex's motion's so-called evidence is not consistent with itself or the trial record. And then it takes us back to State versus Green, which was covered in the first 2 parts of this series, so I won't review that. If you haven't watched, please do, because you'll get all the details of this case and why it's so important to Alex's case. But for now, we'll just say State versus Green was the case that's so much like this one, where instead of the clerk of court, it was a bailiff. But the case went through South Carolina's Supreme Court, and the court's decision was clearly outlined that their solution was to poll the jury with the relevant questions to determine the validity of their verdict, and that this method was highly praised by both the South Carolina Supreme Court and the Court of Appeals. So, these important questions were: was the juror's verdict guilty? Was the juror's verdict based on the evidence presented? Was the juror's verdict influenced by the alleged outside communication? Did the juror have any communication about the case outside of deliberations with the jury? And then it states all the other details are irrelevant window dressing. This is the point. These 4 questions need to be asked. And that was decided by the Supreme Court and approved by the Supreme Court and the Court of Appeals. We mentioned this before, that these allegations that Becky Hill told the jury not to be fooled, to watch Alex closely, to look at his actions, look at his movements, that all of these were in fact stated by the state in both opening and closing statements. And I played those clips a few podcasts back, meaning that they could be mistakenly applied to Becky since time has passed and memory may not be serving well. But looking into Juror 630's recollection in his or her affidavit does not say that Becky Hill said these things, but rather they claim they voted guilty despite some questions, and they felt pressured by the other jurors. So even Juror 630 does not put the blame on Becky, but says, oh, it was pressure by other jurors. So if it's not anything to do with the clerk of court, this affidavit is irrelevant to defense's claims. But in part 2, I mentioned a revelation about one of these jurors who made these claims. I was speaking of this juror, 630, whose affidavit is mentioned here, and you'll see why this is important in just a moment. But what this is boiling down to is this is the only juror who was involved in the verdict that has sworn an affidavit with claims against Becky Hill. We're going to have reason to doubt her claims in just a moment. But here's our case study for the day. They cite State v. Franklin as a case involving pressure by the jury, because that's what Juror 630 is claiming, pressure by other jurors. Here's the thing. A jury is made up of people, imperfect people. People are problematic. I have issues with crowds. Sometimes I look at situations and decide if they're too people-y for me. My definition of my word people-y is not just about a crowd, but how that particular crowd is acting. If it's just a normal crowd going about their business, it's not by my definition people-y. If they're loud, looking for attention, or aggressive, then right there, people-y, and I want no part of it. So it's like that with juries. Some jurors are cooperative. They're there to do their jobs and be done. It works really well when you have a whole jury like this. But some juries have those people who want everything their way and expect everyone to listen to them. Or you have the contrary ones that want to pick the opposing side just to argue. Or the ones that cannot for the life of them make a decision. And on the opposite side, those with no patience who get openly angry and impatient towards them. People-y. It's problematic, but it goes with the territory of picking juries from the general public. No amount of voir dire can effectively rule out all types of personalities that can wreck a jury. But here's the thing, we have to make do with that system because that's the system the U.S. government has appointed here. The court system is already overloaded, understaffed in many cases, and under-budgeted in most, if not all cases. So it's impossible to allow mistrials or do-overs for every little bump in the road. Does that mean some people don't get proper justice? No, it means the court is not going to treat juries like it's daycare and listen to who whines the loudest. They're going to review the cases and weed out situations that, although unpleasant, are not actual obstacles to due process. Due process of law requires that the proceedings shall be fair, but fairness is relative, not absolute. What is fair in one set of circumstances may be seen as tyranny in others. So Supreme Courts, whether they be state or the actual Supreme Court of the United States, have to carefully consider whether a jury complaint actually affected the verdict or was simply an uncomfortable experience for one or more juror. True denial of due process would be some kind of bias or prejudice, racially, sexually, etc. Other things just have to be written off as people doing people-y things. Even when the complaints seem very shocking, if they did not deny due process, they're simply what? People-y. And that's what we find in this cited case of State versus Franklin. James Michael Franklin was indicted for burglary, second-degree grand larceny, and criminal conspiracy. He was convicted on the criminal conspiracy charge and acquitted of the remaining charges. He He appealed on the ground of internal jury misconduct and the refusal of the trial court to hold an evidentiary hearing on the issue of jury misconduct. Shortly after the court submitted the case to the jury asked to receive a written charge of the elements of each crime. Instead, the court orally instructed the jury again on the elements. Several hours later, the jury sent the court another note asking whether Franklin had pled guilty to conspiracy. The court answered no, and they continued deliberations. Less than an hour after that, the court received yet another note from the jury asking what would happen if they could not reach a unanimous verdict, to which the court gave the jury an Allen charge. What is an Allen charge, or sometimes referred to as a dynamite charge? It is when jurors report to a judge that they simply cannot agree on a verdict. The judge may issue what's called an Allen charge, which is instructions for them to encourage those in the minority to reconsider their position. It's named for a United States Supreme Court case from way back in 1896, Allen versus the United States, in which the court approved such instructions in federal cases. Now, it does have its critics which say it's browbeating the jury, or that it's subtle jury coercion, or that it makes some give in to the pressure of the majority. So because of these reasons, some states have actually banned it. And I made a little map here. The red states are the states where it's banned, and the green where it is still allowed. The reason so many states still allow it is because it's not quite as described by those critics. It does not require jurors to change their votes to reach a verdict. If you conscientiously believe your vote is just, you should not change it for the sake of delivering a verdict. Once a charge is given, if the jurors remain undecided, then additional Allen charges may be issued. However, if repeated Allen charges fail to bring a hung jury to consensus, the judge will eventually have no choice but to declare a mistrial. Now here's an example of how they're worded. This is from the Fifth Circuit, and South Carolina is actually in the Fourth Circuit, but they are pretty standard, regardless of the circuit or even federal. So here's a basic Allen charge, and this will be coming from the judge directly to the jury. Members of the jury, I'm going to ask that you continue your deliberations in an effort to agree upon a verdict and dispose of this case. And I have a few additional comments I would like for you to consider as you do so. This is an important case. If you should fail to agree on a verdict, the case is left open and may be tried again. Any future jury must be selected in the same manner and from the same source as you were chosen, and there is no reason to believe that the case could ever be submitted to 12 men and women more conscientious, more impartial, or more competent to decide it, or that more or clearer evidence could be produced. Those of you who believe that the government has proved the defendant guilty beyond a reasonable doubt should stop and ask yourselves if the evidence is really convincing enough, given that other members of the jury are not convinced. And those of you who believe that the government has not proved the defendant guilty beyond a reasonable doubt should stop and ask yourselves if the doubt you have is a reasonable one, given that other members of the jury do not share your doubt. Remember at all times that no juror is expected to yield a conscientious opinion he or she may have as to the weight or effect of the evidence. But remember also that after full deliberation and consideration of the evidence in this case, it is your duty to agree upon a verdict if you can do so without surrendering your conscientious opinion. You must also remember that if the evidence in the case fails to establish guilt beyond a reasonable doubt, the accused should have your unanimous verdict of not guilty. You may be as leisurely in your deliberations as the occasion may require, and should take all the time which you may feel is necessary. I will ask now that you retire once again and continue your deliberations with these additional comments in mind to be applied, of course, in conjunction with all of the instructions I have previously given to you. So it's really a very balanced, it's not a go get in there and come back with the verdict. Is it reasonable, the opinion you're holding on to? So that's an Allen charge. Now back to the State versus Franklin case. 30 minutes after the judge gave the jurors this Allen charge, they returned with the guilty verdict on the conspiracy charge and not guilty on the burglary and grand larceny charges. After the verdict was given, the trial court entertained questions from the jury. Jury Simmons stayed after the rest of the jury left and told the judge and counsel that she felt guilty because her vote felt coerced. Naturally, Franklin filed a motion for a new trial based on after-discovered evidence. This is exactly the motion that Team Alex filed, with the memorandum to follow the next day stating her guilty verdict came under duress, who coerced her with gender-based comments, derogatory comments, and physical threats. Now, by choosing to say it was gender-based and physical, the attorneys knew what they were doing, because if that could be proven, this is truly denying due process. In her affidavit to support this, however, her accusations were not legitimate situations of gender bias. There was no actual physical threat. It was eye rolls, pacing, name-calling, and such behavior. Though unpleasant, the South Carolina Supreme Court found that her allegations were not sufficient to raise a due process error or that she was coerced into changing her vote, further noting that the integrity of the jury system is jeopardized any time a court finds it necessary to intrude into the internal deliberation process. And finally, such an inquiry should not be lightly made. The South Carolina Supreme Court denied a new trial. So again, over and over, the South Carolina Supreme Court has ruled on cases very similar to Alex's case, and they do not find for the appellant. It's basically a no-take-backs rule. Once you give a verdict, confirm that verdict by jury polling, there's no take-backs. Next, we see the state's examinations of these affidavits show their lack of harmony. They point out that this hearsay affidavit from Juror 326, prepared by Holly Miller, contradicts the statement made by Juror 630 and recalls no such comments being made by Becky Hill. They do recall a trigger warning comment about disturbing images, but those images were disturbing, and such a warning has nothing to do with the verdict. Either way, guilty or not guilty, the pictures were disturbing. And that brings us back to the main point of the two affidavits that were prepared by jurors and not by Holly Miller. Only one of those actually deliberated on the jury, and that juror's affidavit still does not show any effect on the verdict. Egg juror number 785, alternate juror who was never used, 741, simply were not there to deliberate or have any part in the verdict. So it sums up Part 4. Absent any representation that a deliberative juror's decision that Murdaugh was guilty was actually influenced by the improper communications alleged, Murdaugh has failed to make a prima facie showing necessary to justify so much as an evidentiary hearing, let alone a trial. So now they go beyond striking and say this motion should just be denied. Just straight up denied. Hear, hear. Now we move on to Part 5, that if the court decides that an evidentiary hearing is necessary, that these allegations put forth are not even credible. They will not be found to be credible. And here we learn that SLED has already interviewed most of the jurors. One juror declined, and as mentioned in Part 2, Joe McCulloch is representing Egg Juror and this Juror 630, who has not consented to an unconditional interview. Thanks, Joe, by the way. I wonder what Connor Cook thinks of you now, as his former lawyer, that you took attorney's fees and costs for his $1 million settlement from the boat crash, by the way. As I mentioned in the last episode, Joe McCulloch is now representing these jurors, the same Joe McCulloch that represented Connor Cook in the boat crash. Which is why most of us are not that fond of defense lawyers, because there's no integrity. There's just following where the money is. One minute you're against this person, the next minute you're for that person. It's just crazy. I know it's their job, I know it needs to be done, but no integrity just, irks me. Now we get to the first batch of the jurors interviewed, and I read out their complete statements on a previous podcast. I'll link it in the comments along with parts 1 and 2 of this series so that if you miss these, you can just look in comments and click on the links and easily watch them. So if you look across the top of this chart, in the first box, the question was, did you hear remarks on evidence by Clerk Hill? The second one is, did you see one-on-one chats by Clerk Hill with jurors? And the third one is just open. Do you have any other concerns? So here we have Juror 193. On remarks by Becky, no, maybe generally pay attention. Juror 254, watch Murdaugh's body language. Juror 326, no, other than graphic material warning. Juror 530, just plain no. When asked about the chats with jurors one-on-one, Juror 193, 254, and 530 all said no. Juror 326 said yes, but it was about financial stuff and child support, so just general chatting. They mostly had no concerns except for Juror 193, who said if anything that people were overly cautious. And here we get to the revelation of one of the jurors I was talking about. Look at what Juror 544 says. Juror 630, this is the other affidavit juror who would not be interviewed, is a tenant of the egg juror 785 who is upset. How telling is that? Egg juror is my landlord and she's upset. Here's my affidavit. My questions: how was such a relationship even allowed to be on a jury together? This is a relationship where one has authority over the other. One holds their home. So was this their relationship at the time of the trial? Was it disclosed to the court if it was? If not, this is messy in itself, and I would love to hear more details about this. So to me, this is very interesting. Here we have salty, rotten egg juror 785 who is upset. She got kicked off this jury and she's mad. Forget the fact she was out there running her mouth, and had she not been, she would not have been kicked off the jury. But of course, it's not her fault. They were just mean to her. So she's mad. Her tenant knows this. How would she know it? She would only know it if she was told this. So we can just picture the scene. An angry landlord who doesn't have good control of her mouth. As we've already learned, can we just imagine what she must be saying to her tenant? And the tenant, because this woman holds their home, is going to make her landlord happy. So now we have an explanation for this one juror saying these things. It's for the sake of their own home. But again, I would really love to know, was the court aware of this relationship? Because this isn't just we know each other casually outside of here. This is an I'm your landlord, so you should listen to what I say situation. Obviously, this juror has pull over her tenant. So they shouldn't even have been deliberating together in the first place, which egg juror was removed, so they didn't. But had she not been removed, I don't know, that's a bad situation. Juror 544 also says, for the Becky Hill comments, that she just said generally pay attention, look at body language, and be observant. But also in her other concerns, look what she says. She or he, I'm not sure. Warned by counsel Harpootlian of a subpoena if they did not talk. Look at that. Tricky Dick. Juror 589, no to the first two questions. Also, spouse warned by Harpootlian of a subpoena if they did not talk. Juror 630, this is the tenant with the affidavit, the only deliberating juror who has supplied one. No interview at the time of this writing, represented by Joe McCulloch. Juror 729, no about Becky's communication except for generally pay attention, and this juror says that they didn't hear any body language comments. When asked if they saw the clerk chat with others, yes, but again about financial stuff and child support, so just general chatting. Now, other concerns, they deny the statements regarding them in the affidavit of Juror 785. Remember, Juror 785 was accusing Becky Hill of improper conversations one-on-one? Well, this juror is saying, nope. And so far, every other juror has said, no, this didn't happen. The only conversations they overheard were chatting about finances and child support. And this one, the other concern, they were uncomfortable when Harpootlian waved the gun around. Yes, as you should have been. Juror 864 says no, and says it was Creighton Waters in court argument who told the jury to watch body language. So basically, the jury says, Becky said pay attention, look at body language, and be observant. But these two saying that they were basically threatened by Dick that they would be subpoenaed if they didn't talk to him. I mean, good luck getting that subpoena, first of all. And second, that's threatening and attempting to intimidate a juror. I would love to see that addressed in court. And right here, I wanted to mention that in the Adelson case, that's a big one right now. I don't know if you followed it or not. He was just found guilty recently, and the judge denied his attorney's requests to speak to the jury. As I have stated all along, against what several squawkers have come here to comment, it is simply not normal practice for defense attorneys to be able to question jurors, and it is in fact forbidden in many jurisdictions. Here's the proof of that in this case. I have never heard of attorneys from the losing side being allowed to drive up to the doors of jurors from their case outside of this one. And here we go, Tallahassee, Florida. No, you can't go question the jurors. What are you thinking? Right there. The next paragraphs are about other court staff that were interviewed. The jury coordinator reported that he was the interface between the jurors and the court, which means he was around, and he didn't hear Becky or any other person attempt to influence the jurors. No other court staff witnessed any external influence on the jury either. And it summarizes this point saying altogether, the allegations raised in the affidavits provided by Murdaugh can be explained as a combination of simple mistakes and, unfortunately, a non-credible affiant. There's a reasonableness with truth that cannot exist in a pack of lies. When a statement is truthful, there's evidence to support it. When it's lies, it will not withstand questioning, as we see here. This troublesome egg juror, and they mention again, she's purported to be Juror 630's landlord, but she was removed after the court determined that she had improperly conversed about the case with other tenants during the trial. Again, I say, if she's talking to tenants outside of the trial about it, and now she has a tenant that's an actual juror, you know they're talking to. And Juror 785 recalled, "Don't be fooled," supposedly said by Becky Hill. But in an in-camera hearing, right before she was dismissed, the court asked the egg juror if Becky had discussed the case with her or any other jurors to her knowledge. Her answer, "Not that I'm aware of." And we covered this in part 2. Such a nice statement after that. It strains credulity to believe that during the trial, she was not aware of Becky Hill's supposed statements when specifically asked by the court, but suddenly recalls them many months later after learning that Becky published a book. No credibility at all. And this is an excellent summary of this document that it's taken us 3 podcasts to cover, not including the first one where I just read off Becky and the jurors' statements. This covers the main points that number 1, Becky denies the allegations. Number 2, none of the jurors have shown that Becky influenced the verdict. Number 3, jurors were given clear instructions by the court about what evidence to consider. And number 4, jurors reaffirmed their verdict during polling. 5, no juror reported being influenced by any court staff. So that brings us to the conclusion. Wherefore, the state respectfully requests that this court summarily deny Murdaugh's motion for a new trial, or, barring that, convene an evidentiary hearing consistent with that conducted in State v. Green, and upon hearing the testimony of the jurors and witnesses presented, find Murdaugh's allegations to be not credible and deny his motion for a new trial. Respectfully submitted, and this was prepared by Johnny Ellis James, Jr. Thank you, Johnny Ellis James, Jr., for this elegant motion. So next time we're going to cover this latest motion in the Alex Circus, his motion for change of venue or delay of the trial. Till then, this is Cassidy O'Connell saying stay well and stay tuned.